Is AT&T set? We're ready. We're going to go ahead and get started. It's, I was looking at the wrong clock here. We're 1:45, we'll reconvene. And with that, Ms. Taylor, if I'm not mistaken, I guess we're on the property tax refund process. Is that correct?
Correct, yes.
Okay. So with that, let me just begin with some opening remarks, and then we'll call up our first speaker. First of all, I wanted to just thank everybody, especially Ms. Taylor, for pitching in here, helping us out. The issues we're going to be dealing here right now is going to be with the property tax refund process and looking where some of the hangups or delays may be, as well as where some improvements or streamlining could be accomplished. We understand the multiple local agencies are involved in the refund process, including the assessor, the AAB, the auditor, controller, and treasurer tax collector. Our focus today is primarily on the hangups or delays directly or indirectly related to the assessment appeals. And we'll start first with our first, actually, we had him up here. We're going to bring him back up. Mr. Montevino, there we go.
Thank you.
Welcome back.
Thank you. Good afternoon, Chairperson Gaines, honorable members of the board. Bhavit Madhvani again, Deputy County Counsel with the County of Santa Clara, where I advise our Assessment Appeals Board. Thank you for your invitation to speak on this item as well. I'll be very brief on this one. I have some data to present to you from our county that I hope is helpful in your consideration of how to handle this issue going forward, and what the timelines for property tax refunds look like in Santa Clara County. So data from our Department of Tax and Collections does not reflect a significant wait time in property owners receiving tax refunds for secured property tax assessments that receive a lower valuation determination, either through an assessment appeals board hearing officer or by stipulation. Those refunds are issued generally on average within 5 weeks. It can be very tempting, I think, to believe that processes should occur faster or mandate stricter timelines. But I think the reality is that there's so many steps involved for county employees, and the process and issuing of property tax refunds is more complex than we like to believe. So I just want to highlight for you a few steps that go into this. This isn't all-encompassing, just to give you an idea of what county employees do when they process these refunds. They have to verify that the correct person, in fact, receives the refund, which isn't oftentimes the person listed. It's not even the same address potentially as where the subject property is. Oftentimes the taxpayer property owner resides at a different address, so they have to confirm where to actually send it. They have to confirm whether the property owner has any delinquent tax bills for other years, or if they've requested to apply the refund to any other tax year bills. Interest has to be calculated that's owed to the taxpayer. Depending on the amounts, oftentimes supervisor or manager review and approval are needed. There's record keeping for documentation because these are all public funds subject to Public Records Act requests. And then there's the actual issuing of the physical refund check. There's about 8 or 9 more steps that I left out because they're a little more mundane, but I just wanted to give you a flavor of what it looks like in our county. But on average, we're talking about 5 weeks for pretty much most property tax refunds. Thank you again for having me. I'm happy to receive any questions that you have.
Thank you, Mr. Madhvani. And as we're listening to some of these issues that you brought up, actually last fall in our taxpayers' rights advocate hearing included communications challenges between the various offices involved. I had one quick question for you. Can you speak on how the refund process in Santa Clara County has addressed or is addressing that problem right now?
So I think in our county, like probably other counties, there's a couple of different departments involved, and the process will depend on what the hearing is about. So for example, if it's your standard Prop 8 for the current tax year, and then that, let's say a lower valuation decision is made by a hearing officer or board member or by stipulation, The clerk of the board will enter that amount as part of their hearing follow-up. That will then get transmitted electronically to controller treasurer, who will calculate the amount that needs to go out based on interest, which then goes to the Department of Tax and Collections, who issues the physical checkout. The longer ones are ones like, let's say, a Prop 19, where you have multiple intervening years, and there's a lower valuation decision, and then you need to have a calculation of a factored base year to the current year, or there's some other calculation that needs to be done by the assessor's office. That will then obviously require them to do that calculation, then come back to clerk of the board, who will then do it as part of their hearing follow-up, and then the same process that I talked about. But so the ones that involved a little bit longer timeline are the ones that are going back to assessor's office for calculation of factor base year value or Prop 19 values, things like that. In terms of communication, there's groups within each of those departments that are specifically there to handle these valuation decisions and communicate the property tax refund process. So in terms of Assessor Stone's point of having clear people in charge of certain things, I think those processes are there. Is it perfect all the time? Of course not, but on average, it works pretty well.
And even in the long process you mentioned, what kind of timeline are we, what is that usually, how long does that usually take?
I was told the upper range is 6 to 7 weeks. That's from the Department of Tax and Collections. Are there ones that fall above that? I'm sure, but for example, they told me the more straightforward ones usually take 3 to 4 weeks, which is why I fell to an average of about 5.
Thank you. It looks like Member Schaefer, and then we have a couple others that want to speak.
Yes, thank you, Mr. Manabe. You talked about a supervisor would approve a check of a certain financial amount. What is that financial amount?
I believe if it's over $50,000, then it requires a manager approval. I believe supervisors more periodically do review, probably more than just the 50,000. I don't know the exact frequency, but if it's 50,000 or above for the refund amount, then a manager review is required as well.
Has it been 50,000 for a long time, or is that recently inflation adjusted?
I actually don't know the answer to that. I'm happy to follow up and find out how long that's been on the books if you would like.
Well, no, I don't require that. How is it compare with the amount in other counties, our larger counties? Do they have an amount, and is it like 50,000, or do you know?
I unfortunately don't know. I'm sorry, Member Schaefer.
I'm in favor of 3 weeks rather than 6 weeks. Anything you can do to speed up refunds. Thank you.
Understood. Thank you.
Deputy Controller, go ahead.
Thank you, Mr. Vasquez. You mentioned the physical check being mailed. Do you also have an option for electronic transfer into the bank account, like such as direct deposit, and will that shorten the time?
So I hope so, but I don't know the answer to that. I'm thinking no, just because of the process that I was given. Talked about confirming addresses that the check has to go to, but it would seem like that would be logical to have an electronic process. I just don't know the answer. I'm not assigned to advise the Controller Treasurer's Office, so I don't want to speak on behalf of that. But that's something I can get for you in our follow-up as well.
Appreciate that. Thank you.
Yeah.
Chair Gaines. Oh, you're good. Oh. All right, I think we're good. Thank you.
Thank you all. Appreciate you having me.
Next, folks, I think on the agenda, we might have had, we were supposed to have somebody else from LA here with us today, but they're no longer here. Well, they're not here because of, I don't know if people are aware, there's a huge strike going on right now in the county, and several of the staffers were involved with that. So with that, let me move on to our next speaker, which is Brad Marsh, the co-managing shareholder of Greenberg Terrain LLP and vice chair of CADA. And I believe he's here. Here we go. Come on up, Mr. Marsh.
Great, thank you. Thank you, members of the board. Thanks for having me here today to speak with you. This is a great workshop. It's excellent to see you taking the feedback here, really digesting it and searching for these answers, and I think that all the stakeholders here appreciate that. Today I'm here to talk about taxes, which, as we all know and appreciate, are a sensitive point of contact between the government and the citizens. When the county determines that a taxpayer owes it money, a bill is issued, and the bill is either due on a predetermined statutory date, our regular annual property taxes, December 10th, April 10th, or generally the last day of the following month. So it would really never be more than about 60 days if the government sent a taxpayer a bill. But there's no similar timing requirements attributable to refunds. There, as I'll discuss in a minute, are suggestions and sort of, you should do this type things, but nothing with teeth of any real significance. And as we've heard, Santa Clara seems to have a pretty fast timing on their refunds, but a recent questionnaire that went out and the counties responded to showed that the wait time for refunds after an assessment appeals board decision or a stipulation can be as many as 6 or 12 or more months in a county. And that's real money. There's no penalties for the county for this delay. There is, of course, some statutory interest, but that's generally of little solace to taxpayers. And frankly, from the government side, an unnecessary expense for the government to be incurring for any local county. So everyone really does benefit from some form of a timely refund when taxes are due to be returned. We've seen, and I think this is a problem that's acknowledged. And I don't think there's any debate that there is this problem in some counties with getting the refunds back. There was a bill, I believe, the Deputy Controller asked about it earlier, that was introduced recently. That was AB 3134. It did not go anywhere, which I think was wise, but it was a bill that would have cut the interest off for taxpayers if the amounts weren't paid to a taxpayer within 90 days, almost sort of providing an incentive. Not that I would, impute that sort of intent, but it would, certainly not a disincentive to speed up the process. There basically are two big problems as I understand it. And again, please understand that I do have sort of a limited viewpoint being from the taxpayer side. But we did do some research. We've explained, I've sat on calls with the LA County Task Force and talked to others. And the delays in processing seem to be primarily due to this sort of, this handoff process that was referenced by the earlier speaker, in moving it through the departments in the various portions of the county. I think Assessor Stone did an excellent job earlier of explaining how if you track things, you can see where the holdups are. And so but the real first thing that needs to be done is there needs to be a change made to the roll after there's a stipulation or an assessment appeals board hearing. There is a statute that already provides for that. It's Rev and Tax Code 1614. It provides for that to be done on a monthly basis and then passed on and starts to move through the process. I think it would probably be worth investigating these handoffs a little bit more and trying to put either some best practices or perhaps some limitations or other sort of rules around when the handoff of the tasks should occur. The second issue that we hear a lot about is that in some counties, especially if the appeals have taken quite a while to be resolved, the county lacks the information by which to issue the refund itself. In other words, they may not have in a current system, in a current database, the payor of the tax itself. And so not really necessarily know precisely who paid it and therefore who to return it to. This problem is quite large, it's quite big. In our position letter, which we had lodged with the board and which you should have, we did propose two solutions. I don't believe that these are the only possible solutions to it. But I think it's one of these things where sometimes when the problem is complex, small, incremental, reasonable improvements you might hit the solve button. The first one was some suggested new language in the county tax collector manual. I won't go through that and read it in detail, but basically it simply cites to Revenue and Tax Code Section 1614 and explains that the roll change should happen within 30 days. And then also after that explains that the refund should be issued 30 days after that. We think that's in parity with what the government asks from taxpayers, being that the largest window the taxpayer would have to pay an unexpected bill would be 60 days. The second solution is a little more difficult. which is the sort of who do we pay the money to solution. There is precedent in prior law at the state level where they have passed laws allowing the applicant on the form to receive the refund in certain circumstances. Teeing off of that, we have included in our filing some draft language that would extend the number of circumstances in which the applicant on the application could be the person that received the refund without further exploration. Not a ideal or necessarily 100% perfect solution, but I think a good start. Some of the other items that have been tossed around as to help counties to be able to process these refunds include another common issue we see, which is oftentimes property taxes are not paid by the actual owner of the property. They're paid by an escrow company at closing. Or maybe they're paid by a mortgage lender. So oftentimes the mortgage lenders will require the money to be paid early, and then they'll be the one that pays the taxes. And that seems to be one large problem where the county wants to direct the funds back to the mortgage lender or the escrow agent. And maybe there are forms that could be created. Again, I know no one loves creating new forms necessarily, but it would be nice to eliminate perhaps some of these payees as legitimate folks that should receive money back when they're simply an intermediary in the process. And so there's those, and there are other ideas, but that's what I have to present here today. So thank you.
Thank you. Others, let me start with a couple of questions here. One from our Deputy Controller.
Thank you, sir. I appreciate the conciseness of your presentation. So you mentioned the counties don't or not currently assess the penalty, but it is interest. So are you in favor of counties being penalized, and how would you calculate a penalty fee?
Gosh, I don't know if I want to answer the question about whether I'm in favor of counties being penalized. I certainly think there has to be some incentive or some way to motivate timely returns of refunds. I understand that there are multiple players. I don't know how you would necessarily go about trying to penalize, even if you were. So I think that's probably the best way I could answer it. I don't really want to go on record as being in favor of penalizing.
Thank you.
Chair Gaines, go ahead.
In terms of the timeframe for a refund, we had the deputy counsel from Santa Clara County, Madvani, speak to us with regards to a 5-week timeline. And so I was impressed that it was that quick, but I know that it varies drastically statewide. So what is, I think you mentioned 30 days, is that correct?
We were suggesting that 30 days time, which is already the law, to have the roll correction made, and then another 30 days for allowed. So a total of 60 days to get the taxpayer a refund, which would, Santa Clara, according to their statements today, would be well under.
Sure. And has there been discussion about interest paid on money held? Certainly there, with the IRS, if they're holding your money for a longer period of time, they're obligated to pay an interest rate and vice versa.
So the current, any refund you receive from the county at this stage under law is supposed to receive a refund of 3%, the greater of 3%, or what's called the county pooled apportioned rate. And that is the rate that the county is receiving on their own investments.
Yes.
And so the taxpayer is entitled to that under current law and does receive it.
They do, okay. All right, so there's not an issue there in terms of interest being paid out.
I believe there's always, I could probably tell you war stories over, a coffee or something one day, but there are, I would say 99% of the
Generally
time.
speaking,
Yeah.
yes. Yes, okay.
Not a problem.
So then it becomes just more of a question of efficiency and property owners getting access to that money, which they may need.
Yeah, and you know, what's interesting here, and maybe I should have addressed in the comment a little bit earlier, is if it takes 6 months or 12 months for a refund to get issued, it's actually more complicated than just the taxpayer not getting their money. Because what's gonna happen is that somebody might cautiously file another claim for refund or a assessment appeals application in the meantime, wondering if this is getting lost or something. And so you're clogging that system up.
Okay.
And then if you wait, if it's a whole year, that's a whole nother year's tax that's going to need to be calculated and
Yes.
returned by
Right.
someone at the county. So it's actually, the longer it takes, the more cumulative other things sort of become involved.
Sure. Okay. Well, we've had similar things with Prop 19 in terms of people moving, right? And then trying to get a refund for the taxes that they had prepaid and trying to move into the next house and creating cash flow issues. And maybe that's what we're discussing later here on the agenda, I noticed. But thank you. That's helpful. I appreciate it.
Deputy Controller, I think, has another question.
Yeah, I did have another question. Thank you, Chairman. I wanted to speak to your second issue about the lack of information for the payor. So how can we solve that problem on a government end? I mean, the chairman and I, we're on the franchise tax roll. We have quite an extensive database of taxpayers, but how does the county solve this issue? Do they look at the property tax roll, or do we do some outreach?
So with the caveat that it is a little difficult for me to identify the issue precisely because I'm in the private side and not in the government, the way it's been expressed to me so far is one aspect of it is a record retention issue. And so sometimes there just isn't a record of the payor. That may be solved by simply recommending or mandating records requirements. Again, I don't know if that's a great idea. I'm not a records guy, but that seems to me to be a pretty straightforward approach towards that type of an issue. The second sort of aspect of it is it's kind of is the wrong payor. It's the escrow company, it's the title company, it's the mortgage company, it's something along those lines. In those instances, you could pass or a law, I think, or perhaps even some guidance on who could receive that refund in absence of, sort of positive documentation, and/or I think you could eliminate or figure out a better way to deal with these escrows and other intermediaries by making them report when they pay who they're paying on behalf of.
Thank you.
Seeing no other questions, I think we're good. Thank you.
Thank you.
Ms. Taylor, as I noticed on the agenda, before we move on to the next one, is there any public comment or anybody that we know of written?
We do not have any written comments or anyone else in the audience. Would you like to go out to AT&T?
Let's go to AT&T.
AT&T moderator, can you let us know if there's anyone on the line who would like to make a comment on item 3, the property tax refund process?
Very good, ladies and gentlemen. If you have a comment, you may press 1 and then 0. And no one is queuing up. You may continue.
Thank you. With that concludes the presentation on the refund delays issue. Before we move on further, I just wanted to double check. Well, actually, I think I already let folks know that there was a couple, we missed one speaker because of the issue going on in LA. So with that, we'll go ahead and move on to number 4 now, which is the impediments to incorporating technology in small and medium and large-sized counties. With that, we have, let me just open up with some remarks and then we'll get into our first speaker here. This item is focused on incorporating technology to address assessor and appeals-related administrative burdens for counties of various sizes. We understand that the counties of different sizes have different needs and different resources, and the technology updates sometimes are necessary to comply with the newer statutes and regulations like AB 1879 on e-signatures. We anticipate that this item will complement the other items to the extent that technology can be important and part of the solution. With that, we actually heard already from Mr. John Tudor on this item, so we'll go ahead and move on to our second speaker on this, and that's the Honorable Howard Leahy from Humboldt County Assessor, and I see him on the screen. Welcome.
Thank you. Thank you for this opportunity, Board. I appreciate it. I guess my talk will be pretty short. I want to reiterate what Assessor Tudor had talked about, a portal for assessment appeals, which would be beneficial especially for the smaller to medium counties. We just don't have the resources that maybe some of the larger counties do. So we are a megabyte county, and several years ago when we looked at incorporating their assessment appeal module, it was going to cost our clerk of the board about $30,000 a year plus setup costs. And it was just money that budget-wise we just don't have. Currently, our county is facing about a $14 million deficit in its upcoming budget. And so to try to incorporate outside programs like this, it's just not doable at this time. So having something like the portal that would kind of streamline the process. Right now, we both, I believe our clerk of the board as well as our office, the way we track our appeals is with Microsoft Excel spreadsheets. And even though I think we're pretty efficient to the way we are doing it, there's always room for improvement in incorporating technology. But that does take money, which right now, neither my budget or our clerk of the board's budget could afford to incorporate any outside sources to accommodate this kind of technology. We process in the neighborhood of 50 to 60 appeals a year, which isn't a lot, but compared to other counties. But when being smaller, we have multiple duties. So assessment appeals aren't the only tasks that we have. It's the same with our clerk of the board. And so managing these can be a daunting task. And so how we streamline these moving forward is critical. And incorporating some type of technology, like I said, with the portal would be so much more efficient for us. We currently have about 20% of ours to go to continuances. And again, that does drag out the process. And it, as well as the way we track them with our spreadsheets, it's a little cumbersome at times. And I think that, again, that there are ways that we can streamline this process. So hopefully, going forward, I think that our county is not the only one facing some budget challenges, as well as across the state. So funding is, whether we get grants, more grants coming forward or not, that's going to be the critical piece to this. That's all I have. Thank you.
Thank you. Let me turn to my colleagues. I have a couple of quick questions. One, for the counties, I guess I'm looking, and you kind of touched on it, that have with fewer resources for technology, what kind of process would be the most helpful or helped by this technology moving forward?
Ways to be able to track and process our assessment appeals. Right, like I said earlier, right now we track everything with spreadsheets, and so having this portal, I think, could streamline that process and make it a little bit more efficient than we are now.
And I'm assuming that you're talking about the portal that I've heard, I guess, from some of the assessors that it's centered around the whole Prop 19 issue, right?
Well, there's that one, but like Mr. Assessor Tudor talked about, is developing, that would be a separate one for something like assessment appeals. It's not currently in process, but it's been in discussion, and But again, it depends on, we did get some grant funding for the portal for the Prop 19 piece of it. And whether or not there's any funding left over after that's completed or not is the top question. And if not, where would we find additional funding to do something like that?
Okay. Do we have any other questions from any of my colleagues? I don't see any hands. I think we're good. Thank you.
All right, thank you.
With that, we're going to bring back Mr. Paul Waldman from representing, I guess it's from the Ryan Group and also from CADA. Welcome back.
Thank you. So I attacked this from a little bit of a different perspective. I was kind of focusing a little bit more on the sort of e-signature, wet signature situation. And the issue that I was looking at was really where the e-signature situations comes in. It happens both with real property and personal property. With real property, we have applications, letters of authorization, waivers, et cetera. The bigger issue really enters in on personal property. With personal property, you know, you're obviously it's primarily a filing, right? You know, so when we're talking about personal property compliance, we're talking about submitting 571L renditions. And when doing so, there are numerous methods for complying, right? There's electronic filing and there's paper filing. Within the electronic filing, there's different systems to do so. If you're doing a batch filing, if you're filing large number of returns, you can do batch filing. And there's a system that was created by the CAA, Webster Guillory in particular, called the SDR system, right? Secure Data Record. And the Secure Data Record system allows you to batch file through XML a large number of filings. Initially, there was an issue where some counties, I believe, were requiring wet signatures even on the e-filing. And in an attempt to rectify that situation, they came up with AB 1879, which requires e-signatures if you e-file. It requires counties to accept an e-signature on an e-file. The issue that I'm seeing that we're running into is that you have this SDR system that is statewide, but counties can either opt in or not. And of the 58 counties, I believe it is 37 counties have opted into the SDR system. So all the rest of the counties, if you're trying to do batch filing, you're going to have to do that by paper. In addition to the batch filing system, the SDR system, there is the ESDR system. And the ESDR system allows you to individually file online specific renditions. So it's a much more cumbersome process because you have to do it literally one at a time and put all the information in on each one. And of the 58 counties, you had the 37 that have opted into the SDR. And of those 37, about 21, I believe, have opted into the ESDR system. In addition to the ESDR system for single online filing, there is also Megabyte has a filing system in addition to the other things that they provide for the county. The Megabyte system, I believe there's something in the neighborhood of 21 counties that use the Megabyte system for online personal property filing. There's, I believe, 3 counties, the very small ones, Colusa and 1 or 2 others, that have no e-filing at all. What happens when I'm talking to practitioners who do a lot of personal property filing, I don't, but in surveying the ones that do, the issue that they run into is that there are now multiple systems that they need to file with. They need to file some on SDR, some on ESDR, some on megabytes, some by paper. It's not worth it. So they do it all by paper. It makes more sense to use one process to do everything. And so that one process ends up going back to doing it all manually by paper. So I believe that that's really one of the biggest things that needs to be looked at, is to try and develop some more of a consistent statewide process for filing. And that would eliminate a lot of the signature issue if people can do more filing online, particularly with 1879, because now they would have to accept the e-signature. With regard to wet signatures in general, from what I understand, the issue with counties not accepting e-signatures or facsimile signatures of some sort is it's a verification issue. The guidance is that the use of digital signature shall have the same force and effect as the use of a manual signature if and only if it embodies the following attributes. It has to be unique to the person using it, it's capable of verification, it is under the sole control of the person using it, and it's linked to data in such a manner that the data were changed, the digital signature is invalidated, and it conforms to regulations adopted by the Secretary of State. So that's the guidance on e-signatures. The key here appears to be that number 2. It is capable of verification. At least from in discussions I've had with assessor personnel, that's the problem, is it's not verified. And so the question then becomes, is there a way to solve that in such a way that people can use digital signatures on a more wide scale basis? Obviously, the first solution I talked about was improve online filing. The second solution is to figure out some way to allow them to verify a digital signature. I believe there's a couple options. Now, you know, the standard when it comes to actual process of a digital signature is DocuSign, right? That's the company everybody knows. There are some other smaller companies that do it, but when you talk about that, you talk about DocuSign. And I actually talked to DocuSign, and there is a cost to use it. It varies depending on how big it is. If you're a very small county, it could be as much as, you know, a little under $5 a signature. So it's not nothing. You know, there's some cost there. It's not super onerous. As you get into more of a medium-sized county, that cost drops substantially. From what I understand, many of the large counties currently have DocuSign, and they do use it. So, interestingly, I know that, for example, I'm told Orange County does have a DocuSign account, but I know they also require wet signatures. So I think there's some, I think there has to be some analysis to figure out, you know, if they're accepting digital signatures in one way, why are they not accepting it in other ways? So I think maybe there needs to be some survey done or some analysis done to figure out why they're accepting it in certain circumstances and not in others. And I imagine that's probably true across many of the counties. That's the primary issue. One solution that I thought of, or someone had mentioned it to me, was possibly the idea of a signature card, right? You know, when you have a bank, you have a signature card on file. There could be a signature card of some sort on file with, you know, your signature and maybe a digital facsimile signature of some sort that verifies it, so that you don't then have to wet sign literally every document that you send in, if you can do it once. Those are, I think, some of the issues that we're seeing with regard to doing that. So there could be some requirement to pay some kind of fee if you're going to use a digital signature. They, you know, certainly the counties, if there's some way for the counties to recover their costs, maybe on a personal property bill, if they could put a direct assessment, you know, of some sort, a small, a couple dollars that would cover the cost for any electronic filing. I believe there's got to be some way that they ought to be able to defray that processing cost if it's onerous on them. So that's really all I have with regard to the technology, just in terms of the personal property filing and the electronic signature.
We have a couple of questions. Let me start with Member Schaefer at the end.
Yes, is there a substantial penalty attached to abusing the electronic signature? You know, it shouldn't be a misdemeanor. It should be both a mortal sin and a felony. I've been a victim of forged signatures, which, because I don't know about it for 10 years, the statute of limitations wipes me out. So I think there should be substantial sanctions available on that, and I wonder if there's, you have any thoughts on that?
Yeah, I agree. I'm not sure what the penalties are in that situation if you abuse that. But I agree. I think that's one solution, is that if there's a substantial penalty for that. And I appreciate you bringing that up, because there was one thing I forgot to mention, that one of the issues when it comes to a wet signature with filing, there are some counties that issue a 10% penalty on your personal property filing if it doesn't have a wet signature. And so you could substantively comply. You could send in your 571L rendition on the date that it is due, and even potentially have it signed, but have it digitally signed. But if you don't have a wet signature, they issue a 10% penalty. Now, and I know you can request to have it abated. I happen to know one situation, someone mentioned to me that they received that penalty. They requested it to be abated, and it was abated. But that is a really onerous penalty for something that seems very inconsequential, particularly when you consider in the term, in the situation of an appeal application. Right, if we turn in an appeal application and there's a problem with it, including with the signature, right, after the deadline, the county boards, the clerk of the board will send you a notice saying, hey, you need to correct this, and you've got, X number of days to correct it. And if you don't correct it, then eventually they'll deny it, and then you have to request them to have it reinstated, et cetera. But there is a process to correct it. But with the personal property in some counties, if it's not corrected before the deadline, it's too late. And then you'd have to request the penalty be abated, and it's up to the county whether they choose to do that or not. So I believe that that's a real issue.
Thank you.
Mm-hmm.
Yeah. Deputy Controller, go ahead.
Thank you, Mr. Vasquez. I just want to make sure I'm clear. So when you're submitting a document to a county, that there's a processing fee from the county, and then there's also a charge from a DocuSign for the wet signature, correct? Or the e-signature. So there's a double fee for the same document.
So my understanding is if the county has an account with DocuSign, and you go onto the county website, there's a hyperlink, you click on that hyperlink, and that allows you to do a form via DocuSign. The county incurs a fee with DocuSign. So there's a charge to the county. So I believe somehow they ought to be able to pass that through.
But not a charge to the taxpayer?
Yeah.
Okay, understood. Thank you.
Okay, but
Go ahead, Chair Gaines.
that could be passed on though, too.
Yeah, I believe that would be a solution, would be if they can pass that along, then that's not a financial burden to the county.
Right, and it's a means of convenience for the taxpayer,
Right.
so.
And if you don't want to do that, you could wet signature, right?
Right,
You know,
and
and
that- does
that
that-
saves you the processing fee.
Does that help with the smaller counties? I would imagine that if it's no cost or a slight cost, they should be able to incorporate that. Am I missing something?
I don't think so. I believe that should be the case, that there ought to be some way to do it.
Okay, great, thank you.
And one other thing I wanted to mention, by the way, the CCIATA, the Honorable Mr. Tudor, Assessor Tudor, He's talking about working on these sort of statewide technological platforms. Certainly the personal property filing would be good to take another look at it.
In what respect?
Well, it would be better if there was, if somehow I guess the question is, the first question is, why are many counties not opting into the SDR system? Right, it's already there, it's done, it's set up, they just have to opt in. So there's some reason they're not doing it. And is there a cost? I'm not sure what the issue is, or whether the technological platform doesn't work for them somehow, and maybe something needs to be done with that. And also the ESDR system / megabyte system, both those systems are very cumbersome. So if those could be rewritten in such a way that it would make it easier for everyone to file online, I think that would solve a lot of problems.
Sure, all right, thank you.
Controller, I think you have another
I
question?
did have one more follow-up question with AB 1879. Was that a bill you were in support of, and do you think that bill had enough teeth, enforcement? Or are you looking for something more?
The issue that I see with AB 1879 is it requires counties to accept a digital signature when something is e-filed. If it is not e-filed, then they don't have to, apparently, it's not an e-signature, it's not required that they accept an e-signature. And because of the issues with e-filing, many people don't do it, so that kind of eliminates that benefit that you get from it. Do you follow me?
I do follow you. So if you were a legislator and you put a bill forward, what would it look like in terms of e-signatures?
I don't know that I have an answer off the top of my head for that. I would certainly like to, I would like to see e-signatures of some sort be, counties required to accept it in one way or the other, but I understand that there could potentially burdens on the counties to do that. So I don't have the final solution here.
Understood. And we've heard from counties, some counties only have 2-3 staff. Then there's just not, they don't have the capacity to take that on at this moment. So, I mean, it's the issue twofold. So we'll continue to work on it. Thank you.
Yeah, I understand that. Thank you.
Thank you. This has been real helpful. You kind of just went a little last, you mentioned to the extent that you can centralize, I guess, the list of the counties which are accepting e-signatures. Is that something that would be helpful if, like, the BOE was to be the house that?
Yes, and that was something I did include in my package. Was it would be helpful to have a comprehensive list of what counties accept e-filing, what counties have SDR, ESDR, megabyte, what counties require what signatures and for what. Yes, I believe a comprehensive list like that would certainly be a first step in the right direction, pending a more comprehensive solution.
Thank you. I think we're good. Thank you.
Thank you, members. Appreciate your time.
With that, Ms. Taylor, do we have any public comment, any written on this before we move off this item?
Yeah, we do not have any written comments on this, and I don't believe anyone's asked in the room. So if you'd like to go out to AT&T. AT&T moderator, can you let us know if there's anyone who would like to make a comment on this item, number 4, impediments to incorporating technology?
Thank you. If you would like to make a comment on number 4, please go ahead and press 1 then 0 at this time. Again, if you have a comment on item number 4, please press 1 then 0.
Actually, Ms. Taylor, for the record.
And no one has queued
I
up.
think this is item 3. Or is it?
It's number 4 on the agenda, but it's the third topic.
Oh, okay. All right, as long as we know. Thank you.
No one has queued up on the phone lines.
Okay, with that, then that concludes the presentation on technology issues. And I believe we can go ahead now and move on to our next item, which is Proposition 19, Challenges, Administrative Burdens, and Implementation Questions. With this, let me just open up with, this item is divided into two sub-items. The first is the base year value transfer issue, and the second is the intergenerational transfer issues. Rather than stopping for public comments after each item, we will hear from all the Prop 19 folks, presenters first, and then move on with some comments on that. In addition, while the CADA speaker is listed under each sub-item, we anticipate that they will make one presentation prior to the public comment. I believe that's correct. And with that, let's begin with our first speaker. And actually, we heard from the first one was John Tudor already spoke on this issue. So our second speaker will bring back Mr. Howard Lay. Yeah, I believe he's still here. Oh, he's up on the screen now.
Thank you. Thank you again for the opportunity, board. I appreciate it. So Prop 19 has, when it was first passed, it was a pretty vague proposition, and there was a lot of work on the assessors as well as the Board of Equalization staff in defining what was Prop 19 and what did it mean, not only base year but also intergenerational as well, which included family farms and so forth. This proposition has drastically increased the workload on all assessors throughout the state, all 58 counties. Like I said earlier, the board has worked really well in defining a lot of the areas, but to me, the biggest piece of it that is really vague is the family farm piece of it. It is so wide open. The definition, like for instance, in our county, it includes timber. Well, 99% of the properties either grow timber or potentially grow timber in Humboldt County. And so when we get a Proposition 19 claim for the family farm, we've actually had to gone to assessment appeals with it. We've had some challenges on there, and when we've reached out to the Board of Equalization for clarity, because we had an active appeal, they wouldn't weigh in on it. And so we were kind of left to try to kind of fuddle our way through it. I just feel that I think that piece of it really needs more definition. And I think that several other county assessors would agree that the family farm is, in my interpretation, I think the intent of that piece of it was supposed to be for commercially ag producing properties. And we've had everything from a person planting an almond tree in their yard to having a vegetable garden in their backyard to qualifying as a family farm. And so I think that we've all really struggled with that, with appeals as well. And if we could somehow get that defined a little better, I think it would be helpful for all county assessors. That's pretty much all I have on that.
Thank you. Any questions or comments? Seeing none, I think we're good. Actually, you know what? I do have one, and it's, what do you think are the most important things that the BOE can provide to help you with other small counties in terms of providing relief for those Prop 19 issues you're facing?
Like I said, when we've had assessment appeals and on a Prop 19 situation, and because it was an active appeal, they wouldn't respond to us. And the only way they would is if we get consent from the applicant to do so. And in both cases, the applicant wouldn't respond. And so we were kind of left to try to figure it out on our own. And so if we had a little bit more support, and I guess legally I understand where they're coming from, but those kind of scenarios, having more support from the board would be helpful.
Okay, thank you. With that, it looks like we're going to bring back Speaker Brad Marsh is back on this issue as well.
Nothing unites people like hatred for Prop 19.
I
I think we can all agree that it's imperfect, not necessarily well thought out, creates compliance and administrative nightmares. CADA's proposal that I'm presenting today, however, is much less fantastic than, sort of just doing away with it or anything like that. It's the law at this point, and I think we all are sort of stuck dealing with it. We are focused on two main aspects. The first is, in order to achieve the exemption, there is a need for a continuing resident to be a child or be, a part of the family in the family home or on the family farm. And this does require the assessor to check in on the ownership and the residency of the property, which is, again, I think an administrative hassle and what have you. We simply point out that we think that to the extent that there are notices or other items that are mailed to folks, to homeowners, that they have bolded attention-grabbing type headlines so that it doesn't lead to further disputes over the applicability of the exemption, leads to higher compliance by taxpayers, et cetera. Also, I'm a tax lawyer. I do a lot of different state and local taxes, mostly property tax. But one thing that I've learned from my time practicing is that one of the other most effective things that can be done is to work hand in hand with other professional organizations in educating them about the requirements, because many folks have a tax preparer for their federal tax returns. Some folks have attorneys and what have you, so accountants, tax advisors, what have you, in putting on educational programs, making someone available either on a county level or at some of the statewide organizations to go through the requirements and hit the high points so that the advisors to these people are in a position to comply. Again, trying to take care of the largest swath of people with the least amount of effort possible. Also, of course, when you have all the advisors telling their people what needs to be done and why it needs to be done, people talk, homeowners talk. And then the last comment I think we have is that there is sort of a less paid attention to property tax exemption out there right now, which is the homeowner's exemption. $7,000 a year saves about $70 for a homeowner. It may be worth considering how the Prop 19 continuing residency compliance can be tied in to the homeowner's exemption and coordinating those two activities, because there's a lot of overlap between what they're trying to do. So that's all of the comments on behalf of CADA on this subject.
Thank you. It looks like we have a question here from our chair, James.
Yeah, that's interesting that you could tie that into the homeowner's exemption. Is there current verification that's occurring with county assessors for that?
So the way that the homeowner's exemption is currently claimed is typically when you buy a house, you fill out a form and you send it in, and it's a non-recurring compliance issue, which, I'm on the private side. I have seen taxpayers who have homeowners exemptions on properties that they're renting out, and I tell them, hey, time to fix that, right? I wouldn't say that's frequent, but I think the assessors may have more stories if they were asked about situations where there was improperly claimed exemptions and what have you, and maybe they would appreciate, it's just a suggestion, open for discussion in a work group, but maybe they would appreciate having a way to upgrade their intelligence on the homeowners exemption at the same time as dealing with the Prop 19.
Yes, yeah, that's an interesting approach and maybe a solution. Yeah, thank you.
Member Schaefer, I think has a question.
I like your suggestion of larger type, maybe a little red letters. That's a good one.
Any other comments or questions? I think we're good. Thank you.
Thank you.
With that, folks, let me just go to this last part of it. We have the discuss Prop 19, the intergenerational transfer problems. We know that intergenerational transfers were fundamentally changed by Prop 19, and that there are many outstanding questions from assessors, professionals, and the general public, still creating administrative burdens for all. Our first speakers from the Sacramento County Assessor's Office are both in person here, and it's Mr. Jarrett, is it Stedford, I believe is here, and then also the Assistant Assessor, and Miss Linda Cogburn. Chief Appraiser, if you would please come up. Welcome.
Thank you.
Welcome.
Good afternoon, honorable board members. I am Jarrett Stedefor. I'm the Assistant Assessor of Sacramento County, and with me today is Linda Cogburn. She's the Chief Appraiser in charge of our Standards Division. We have prepared a slide deck for you. I'm not sure if we can bring it up. Looks like you're getting hard copies of it.
Well, it's behind them.
So, oh, there it is. Okay, great. All right, well, on behalf of Sacramento County Assessor Christina Nguyen, I'd like to thank the board for this opportunity to speak at this work group meeting. Could you go to the next slide, please? Our focus today is to share specific examples of Prop 19 intergenerational claims that were approved either prospectively or denied altogether due to the lengthy processes of probate and trust settlement. We have asked for board guidance on these scenarios back in November of 2024, so I'm sure that guidance is working its way through the board currently. Could you go to the next slide, please? These examples show the unintended consequences of Prop 19 to the taxpayers of our state. Okay, and again to the next slide. Thank you. Example 1, a father passed away March 17th of 2022. He had a will that named his son as the beneficiary, but probate was required. The son was awarded the house by court order in December of 2023, and that recorded on January 22nd, 2024. The son occupied the house before and after the date of death, but did not file the homeowner's exemption until he was awarded the house. In this example, the taxpayer received prospective relief, and it resulted in the taxpayer paying an additional $3,972 in supplemental bills. Okay, could we go to the next slide? Example 2, a father passed away February 28th of 2022. He had a will that named his son as the beneficiary, but again, probate was required. The son was awarded the house by court order on April 11th, 2023. The son was not occupying the house on the date of death. Therefore, pursuant to the probate referee, the house was locked and could not be occupied until probate was settled. Once probate was settled, the son was awarded the house, he occupied it as his residence, and filed the homeowner's exemption. The claim was denied. This denial resulted in the annual tax bill increasing from $1,264 to $3,370 per year, or a difference of $2,106 every year. Okay, could we go to the next slide? Example 3, a mother passed away September 10th of 2021. She had a trust that named her son and 3 other siblings as beneficiaries. None of the children were occupying the property, and the executor locked the house until the trust was settled. Once the trust was settled and the son was awarded the home, he occupied it as his residence and filed the homeowner's exemption within a year of the trust settlement. This claim was denied. The denial resulted in the annual tax bill increasing from $787, which is obviously a old base year value we had on there, up to $4,245 per year. And again, this difference of $34.58 is year over year. Several of these instances have resulted in assessment appeals brought before our Assessment Appeals Board. And in each of these cases, the appeals board ruled in favor of the county. Attorneys that represented those taxpayers in these instances are saying they intend to pursue the matter in court. With that, I'm just the bearer of bad news. I'd like to turn it over to the presentation for Linda Cogburn so she can explain some potential solutions for you.
Thank you, Jared. Just a quick note, because you might be wondering where this is coming from. I have 23 years' experience in property tax. I started as an assessment tech, and I processed a lot of parent-child exclusions and a lot of base year value transfers even before Prop 19 under the old rules, okay? I became an appraiser. I did res, commercial. I was a supervisor, and now chief of standards. Next slide, please. Okay, so I really think the law may provide an answer. I think it might be staring us in the face. So I wanted to bring this to your attention. That is a link to the Constitution at Article 13A, Section 2.1. Subdivision C1 states in part, for the purposes of Subdivision A of Section 2, the terms purchased and change in ownership do not include the purchase or transfer of a family home of the transferor in a case of a transfer between parents and their children, as defined by the legislature, if the property continues to be the family home of the transferee. Now, this, still part of the law here, this subdivision shall apply to both voluntary transfers and transfers resulting from a court order or judicial decree. Now, if you read on down to subdivision C5, I'm not going to read the whole thing to you. I just want to point out it says that the homeowners or disabled vet exemption has to be filed within 1 year, okay? And so that's what the Constitution said in Prop 19. That's what the voters said, right? The BOE wrote some great rules. We so much appreciate the rules that the BOE wrote because we needed the clarification on so many levels. One thing that the rules do say, and I'm actually quoting a different rule, but it does say inheritance is effective as of the date of death. I just want to bring that to your attention. I want to point out these two examples. This is why the appeals board didn't have a choice, is because they're interpreting these laws the same way the Board of Equalization is. Example 15, I'm not going to read the whole thing. It's a case scenario pretty much identical to one of the ones that Jared read to you in our situation. But because the child did not file the homeowner's exemption within a year of the transfer, that is the date of death, he is only eligible for prospective relief, okay? In 16, because the child did not move into the property within 1 year, because probate locked the house and would not allow them, they are not eligible at all. Not eligible at all. Next slide, please. So, just bringing to your attention what we read in the Constitution. First of all, that transfers, whether they're voluntary or involuntary, resulting from a court order or a judicial decree. I'm kind of curious that it didn't even mention deaths here, you know? It mentioned a court order or judicial decree. Very interesting. I'm just wondering, if, and I lost my slide, does the date property is awarded to the heir affect that 1 year requirement? Because there's really no definitions about this. Can regulations be revised to accommodate probate proceedings or trust proceedings? Can a regulation define the following terms? Court-ordered transfer, trust settlements within a year. One other piece of information for you. Revenue and Taxation Code 60, definition of a change in ownership means a transfer of the present interest in real property, including the beneficial use thereof, the value of which is substantially equal to the value of the fee interest. Now, I'm not an attorney, I'm an appraiser. I know there's attorneys out here could probably define that, but I believe they're talking about the full bundle of rights. A right to finance the property, a right to just enjoy the property. Heirs that are held up by probate or trust proceedings don't have the beneficial use of the property, and they don't have the full bundle of rights that are suggested by a fee interest title. And so we're hoping you can shed some clarity on this for us. And with that, do you have any questions?
No, this is great. I really appreciate the fact that you're able to bring real situations that are actually occurring, right? On the law.
Yes.
I wasn't aware of some of these, especially the one when you're talking about the probate situation, because I know several families in my district that are going through it and don't have access to it because legally nobody owns it because they didn't have a will or a trust. And until that gets settled, they're sitting out in the cold. By the time it does, the year expires.
That's exactly right.
Yeah, it's a real situation. Other questions? It looks like.
If I could.
Yes, go ahead.
Yeah,
Mr.
because
Gaines.
I'm just curious about, a lot of folks get a living trust, so they can transfer that ownership to the children or whatever. So it's just, these examples seem like they're all probate related, but I'm trying to figure out proportionally.
These are all different.
Okay,
These are all separate claimants.
okay.
We could have given you more, but, time, 10 minutes. And so we didn't do that. No, these are all separate. But there are times in a trust situation where you may have 3 or 4 siblings, and the trust is responsible to give them an equal share of 10 properties. What is that? And then there could be some arguments that take them to court to make that ruling.
Sure,
And so that could take more than a year.
right. Or it could just be the home, right? And then you got to figure out,
Right.
do you have to kick in some cash as one of the children to buy the home? You've
Exactly.
got to negotiate with siblings or whatever.
And in the
So-
meantime, they can't move in
Yeah,
Right.
because until it's decided,
Legally, they don't own it.
they can't move in.
yeah. I think you raised a good question. I'd like to examine that and see if maybe we could do something to help relieve that.
Chair,
Yeah, thank you.
Go ahead, Schaefer. Member Schaefer.
is there such thing as virtual occupancy?
I like it. And I wish it was a grounds, a legal
You've
grounds.
been reading the AI articles too much now. Any other questions? No, I think this is helpful because like you mentioned, we assume it's just because of a probate situation, but I know some that are in a trust that are in the same situation. Because when you have more than one sibling, sometimes they don't all agree. And by the time you get a court to rule on it, you're looking year 2, if you're lucky.
And these are our communities. It's going to
Right.
touch us all.
And I think the sad thing about it, when they created this legislation, I don't think people really thought it through.
No,
Yeah,
Unintended consequences.
that's right.
yeah.
Yeah.
All right, thank you.
Thank you so
Thank
much.
you.
Thank you.
With that, I think we have, is Robert Gomez here? Oh, he's on the screen. Yeah, our next speaker is Robert Gomez, Division Chief of Assessment Services for the San Diego County Assessor's Office. Welcome, Mr. Gomez, if you're online. And he is, okay. I understand you will address various Prop 19 burdens which have risen in San Diego County, and to the extent that they may impact other administrative processes, including the AAB, appeals, and refunds. Mr. Gomez, you have the floor.
Good afternoon, and thank you, Mr. Vasquez, Mr. Chair, Honorable Board. Thank you for inviting me to this session on behalf of Jordan Marks, our Honorable Assessor in San Diego County. I'd like to give you some more tidbits. Sacramento County did a great job, and my colleagues over there in Sacramento. You're preaching the choir over here in San Diego, and I think across the state. So great job on that. And I have a couple things to add to that, so I won't regurgitate what they said. But I want to touch in on that topic that how can we fix this? And what I was thinking is, and it's not going to be easy, but it will take a constitutional amendment. If we can up the homeowner's exemption claim filing to 3 years to mirror the parent-child exclusion form, which is 3 years, I think that would be a good panacea to fix all the problems that we're experiencing today as far as late filing denials and prospective relief. Well, let me share my screen here. So this screen here is an illustration of kind of the calculus math that we have to do now that the law directed us away from assessment value to market value. And a little background about myself. I started my career at the Orange County Assessor in the late 90s, and now I'm here at the San Diego County Assessor. So I have a combined experience of 27 years in this type of administration with change of ownership and exemptions. Here's one example that really gets a sticker shock when we go out and do presentations in our county. In this case, we have a death occurred on 4/3 of 21, so we're within that Prop 19 realm. And the factored base year value, which is your assessed Prop 13 value, at the point was $348,321. However, at the time of this transaction, since now we have to look at the market value and not the assessed value, we found out that the fair market value of this property is $1.8 million. So what the law tells us is that, and the complexity behind this new law is that everybody's cap is different. You know, before it was very, very easy to come up with. Now, the reason why everybody's cap is different is because the law tells us, or the code tells us, it's your assessed value, which everybody has a different assessed value, plus $1 million for the most part. So in this sample, their assessed value was $348,000 plus $1 million. So their cap was 1.348. So here's how we have to calculate this now. We have, once we get all of our data in line, we look at the market value, which is 1.8. We subtract their cap, which is 1.348. That gives us an excess amount of $451,000. Well, what does that mean? This is because they went over, because the market value exceeded their cap. That has to be added on to create a blended base year. And what does that mean? Well, here's how we calculate that. This $451,000 was the amount that was over the cap. Now we have to take that number and add it to their assessed value at the time of transfer, which is $348,000. Those two figures create a blended base year value of $800,000. The reason why I want to show you this example is this is a property, as you can tell, it hasn't been reassessed in quite some time. One of our coastal properties are in San Diego. And they're receiving the full benefit of the law. They're receiving the full cap, but their bill goes from paying $3,400, so to speak, at 1% to now $8,000. This is the one that Jordan and I show when we educate our constituents as far as attorneys, fiduciaries, and sales reps. This is what we go out and tell folks, that this is a scenario where they got the full extension and their bill more than doubled. Sorry. Another issue that we're having is when we're tracking the primary residency and we find out that somebody has moved out or they entered into a legal entity. We haven't had any scenarios where somebody has moved out to where we need to go back and refactor that market value. But we've had scenarios where folks have had the exclusion for a couple of years and then decided to transfer their property into an LLC. That in itself forces us to remove the exclusion on the next lien date following that transaction, because LLCs do not qualify for the parent-child exclusion. And let me show you some of the calculations that we have to go through. Here's an example here where we have to remove the exclusion. And they do, it's not just 100%, there's also partial interest, which muck it up even more. So in this scenario, the transfer happened on May 12th of 2021, so we're within Prop 19. The parents decided to retain 30% and they want to give 70% to their child. That's fine, we can do that. The factor base year value, the assessed value at the time of transfer was 300,000. And then the fair market value, we figured out to be 1.5 million at the time. When the son decided to move out on July 20th of 2026, that forced us to go back and see, okay, what was the market value at the time he received the property? And we have to factor in that, up to 2% CPI inflation factor for every year he had it. So in this case, he had it for 10 years, decided to move out, but keep the property. And now he's going to get a huge sticker shock of, instead of having a new blended base year of taxable value of 485,000 through the years of getting the 2% increase, that is going to inflate to 1.2 million on the lien date of 2027. And this is, I don't know if this is happening as much because it's a fairly new law, but these are the kind of issues that this law has forced us to be hawkish on. Normally when we apply an exclusion, we apply the exclusion and we move on. We never have to go back and check it. There's no requirements for that. This law forced us to make sure that it's continued as a primary residence. And how do we find out? Sometimes people call us or email us. Sometimes neighbors tattle on each other. There's times where they'll say, I don't want the homeowner exemption anymore, or they change their mailing address. These are indicators that we would investigate to see if we need to remove it or not. There is, my colleagues did reference a bill that cleared up a lot of ambiguity here, like everybody else, when this law passed and became effective on, 2/16 of 2021, we were kind of like, oh, wow, there's so much ambiguity. There's so much, information that we need answers to, that about 5 months later after that passing in July 12th of 2021, we got Senate Bill 539 that was chaptered the next year. And that cleared up a lot of ambiguity of a lot of questions that we had that we ourselves didn't know how to administer. So, but here in San Diego, we didn't let COVID or ambiguity stop us from most things. We were continuing to work these claims as we go, but we had to set aside some that we needed questions on. And other than that, that is all I have to present. I don't want to duplicate the efforts of the fine folks in Sacramento County. Did a great job. I'm open for any questions that anybody might have.
Thank you. I see several hands. Let me start with our Chair Gaines. Go ahead.
That first slide, I don't know if you can show it again or not, but I really, something came to light when I saw that, because in that base year value transfer, it's my understanding that when that move occurs to a new county, and we could use like a county up in this area, isn't there supposed to be a transfer of money from the gain, right? Because as a result of the reappraisal of the property, it was explained to me that there was going to be some sort of offset coming to the counties that these individuals move into.
Yeah, I believe, Mr. Gaines, Mr. Chair, that you're referring to the base year value transfers of those who are 55 and over?
Yes. Sorry, I didn't specify that, but yes.
No, that's okay. I just want to clarify for everybody else, because they do get fuddled because it's a two-part thing. And for the intergenerational, it's effective on February 16th of 2021. But this on the base year value transfers, that was effective on April 1st of 2021. No pun intended for April Fool's Day, right? So yes, there has to be a sale made. Now, the problem that other counties are facing is that if I have if I have a home that I've owned for 20 years in a coastal area, where maybe my assessed value is $500,000, but it's worth $4 million. Now I decide to go over to Humboldt County, or I decide to go to Colusa County, or some of the smaller counties.
That's right.
I transfer over there. They're losing that sale because I can transfer my tax base from San Diego to them. So the smaller counties are suffering a huge loss in value because of these.
But wasn't there supposed to be some transfer of revenue through Prop 19 that would go to that new county? And I don't think that's happened yet.
The California Department of Tax and Fee Administration have been petitioning the counties, soliciting the counties for quarterly data to capture this so they can do what you're talking about.
Okay. Gosh, I'd sure like to look into that and figure out why that hasn't happened. I know that a lot of these rural counties are lacking in revenue, so.
Yvette Stowers, Executive Director. It's a two-part step. Yes, CDTFA is soliciting the counties so they can show their revenue loss or their revenue gain. And then but the first step is for the Department of Finance to do a calculation to see if there's a net increase in revenue. And that's what they've done every year. And so far, it has not been a net increase. Once there is a net increase, Department of Finance will instruct the state controller to fund two accounts. And one would be to fund the firefighters, and the other one would be for the counties so that they can be made whole.
Right, we talked about firefighters yesterday, not getting any money.
So
But you're saying there's no,
At this
how
time,
can there not be a?
the latest calculation, August 30th, 2024, they concluded that there was not a net increase in revenue. They're looking at property tax revenue and income tax revenue. And if one goes up, unfortunately, the other one goes down. So we have not seen an overall increase.
Oh, okay, so it's tied into income tax too?
Yes, it's tied in.
I didn't know that.
Yes, it's the way they're doing the calculation. They're looking, well, if, in this particular example, someone's gonna have a huge property tax bill. So you would think that's an increase in revenue for one county. However, person's gonna take a personal income tax deduction on the property tax that they pay.
Okay,
It's balancing that.
interesting. Wow, so are we ever gonna get any money? That's the question.
Well, I'd also like to add the other caveat is that, under the old rules, alternate properties that weren't your principal place of residence could receive some tax savings relief up to $1 million assessed value. With the new law under 63.2 of the Revenue Taxation Code under Prop 19, the alternate properties have been omitted. So now folks can even get any property tax savings for their alternate properties that they own, their family businesses, second homes, rentals, so to speak. So that in itself should create a lot more revenue because we're not allowed to exclude those right now.
That's great, thank you.
Any other questions? Seeing no other questions or comments. We have one last speaker, but I'm looking, I see our Assembly member here, Mike Gibson. I don't know if you had any comments. If you've been listening, or are you good? If you want to come on up before we get our last speaker in here.
Thank you very much.
You have to push that button, I think.
Thank you very much, Mr. Chairman, and to the board members. Thank you for allowing me just to come and weigh in on the conversation. I think it's a timely conversation. So Mike Gibson, Assembly member representing the 65th California State Assembly District. Also, I chair the Assembly Revenue and Taxation Committee. Timely on Proposition 19. I want to offer up a few some thoughts in this space because of your topic today. In this segment, for context purposes, we know that November 2020, California voters passed Proposition 19, which made changes to the property tax benefits for families, seniors, and severely disabled persons and victims of natural disasters here in the state of California. As we, on this particular topic, I would like to opine to both problem and possible solutions regarding this particular component of the law that you're talking about today. The first problem, inheriting of property may not have enough liquid capital to cover an abrupt increase in property tax for small business property. My solution, my opinion, would be to authorize a constitutional amendment to provide the transfer of some amount of these base year values of business property tax when inherited by a child or grandchild. As we all know, Proposition 19 modifies various base year value transfer and changes in ownership exclusion. Among other provisions, the parents and grandparents to children and grandchildren of exclusions when transferring property was restricted, such that only principal place of residence could be in fact transferred. And I think that speaks to Proposition 19. Previously, a primary residence property could be transferred to a child or grandchild without a value limitation. And other types of properties, like a second home or business property, could potentially be transferred depending on the circumstances. Proposition 19 limits the transfer of principal residence to the base year value plus $1 million adjustments, and prohibit transfer of a base year value for other types of property. The second problem I want to offer up, victims of disasters having potential less time to purchase or construct a new property after damage or disaster cannot transfer value of these business properties. The solution, again, I offer is authorizing a constitutional amendment that extends the time to transfer a base year value and allow the transfer of some value of a business property after damages or destruction by this natural devastation that we've seen in recent months. As you know, Proposition 19 also modifies base year values transfers after a disaster. We know this. Proposition 19 did provide certain treatments when transferring the base year value of property damages or destruction. And we know this by the governor's declaration or proclamation of disasters, but that was narrowed in authority, in authorization, Prior to Proposition 19, owners could transfer the base year value of any type of property to another site within the same county. We just had that discussion, within the same county that is purchased or newly constructed within 5 years, so it could qualify as a disaster. However, after property owners must purchase construct the property within 2 years of the sale and of the damaged destruction property, and may only transfer the base year value if they live as that principal residence. And again, my whole reason for being here, because this is something that we have to grapple with. I think there's been unintended consequences as relates to Proposition 19. I have spoken to realtors and things of that nature, and certainly I think we can all agree that this was not the purpose it was intended, and people who have inherited property are adversely affected. And I just want to offer up that when people transfer property, it's to create generational wealth for that particular family. And what we're finding out, they're being disenfranchised. And I think we as policymakers need to do everything we can to address this matter. And again, I offer up my opinion as relates to constitutional amendments, because we know the voters of California voted for this. The only way that we can make modifications if in fact we have a constitutional amendment. So I just offer that up to each and every one of you as you deliberate in this particular space, and I stand ready to work with each and every one of you. I have to return back to the legislature. I have some bills up for hearing right now, but again, we'd love to meet with you individually as well as collectively, see how we can work towards this space, because I have heard people in my district, not only people who have residents, but also realtors who understand the disenfranchisement that this brings as relates to those trying to create generational wealth and pass that on. So I thank you very much for a few moments just to speak with you today.
No, I appreciate it. We've had some real good presentations earlier today from several of the stakeholders, and I think a lot of people realized, obviously, that when this thing was cooked back in 2020, it wasn't a well thought out piece of legislation, and now we're seeing the repercussions of it. And I appreciate that you're willing to step up. And I know several of my colleagues here are trying to come up with hopefully some solutions. But at the end of the day, I think you're right. We have to take it back to the voters, because the modifications that we're looking at are minor. It's not going to address the issue of intergenerational wealth as we know it, as we used to know it prior to Prop 19.
Well, I look forward to engaging with you for next year. We have a limitation on our bills, and I haven't used up all of my bills for 2026. And so I would certainly welcome the opportunity to engage with this body to create some real policies that we can provide to the voters for the next following year. So
Appreciate
thank
it.
you very much.
Wonderful.
I
Appreciate
think
you.
you have a
Thank you.
question here from Member Schaefer.
You were here a few minutes ago. I think the best slide they had was Proposition 19. It looked like Einstein's theory of relativity.
Thank you very much. I'll check that out. I'll be watching and reviewing your meeting so I can catch up on the discussion I missed prior to. But thank you very much for this opportunity.
No, thank you for coming by.
Thank you.
Appreciate your idea. That's a great bill.
With that, we have our last speaker here just to conclude this item, and it's Brad Marsh, which I believe is still, yeah, he's still here with us. Our final speaker on this issue. Welcome back.
Thank you, and I'll be extremely brief. The Sacramento presentation was exceptional, in my view, at illustrating one of the key problems. I'm not, technically, I don't think I'm authorized to speak on CADA on this exact comment I'm about to make. This is more of a personal practitioner comment. I participated in a work group on this exact topic, and we believe that there might be a legislative solution, and minutes of that meeting are being prepared, and I will distribute them for your information once they're finalized. And that's it. That's my only comment.
Appreciate it. With that, that pretty much concludes this item. I'll turn to Ms. Taylor to see if there's any public comment. I don't know if there's any written comment. If not, we'll go to AT&T.
We do not have any written comments, and I don't believe anyone in the room is signed up to speak. So if you'd like to go to AT&T,
Yes, let's go to
AT&T
AT&T.
moderator. AT&T moderator, is there anyone on the line who would like to speak on this item?
If you would like to speak on this item, please press 1 then 0 at this time. And we have no one in queue.
With that, that will conclude this item. We will go into wrap-up now. I will start with some wrap-up comments, and then I'll turn to my colleagues to see if they have any closing remarks as well. First and foremost, I just wanted to thank, and with the utmost gratitude and appreciation to all the speakers that we had here today, not only the stakeholders, but then many of the folks that were here through our Zoom and who made the effort to come out here in person as well as the BOE staff and specifically Ms. Taylor for stepping up and assisting me on this hearing today. I wanted to begin my remarks looking at the BOE, and I guess it's as required for this work group, my office will prepare and provide detailed minutes of all that was said today and try to summarize it with recommendations that we received from the board and review this for approval at our June 18th, 2025 board meeting. Based on the information received and recommendations made today, the work group may want to convene again in September 17th of 2025, but I'll leave that up to my colleagues and staff and see if it's needed. With that, let's start with our chair, Member Gaines, for any closing remarks, and then we'll go to the vice chair and then our deputy controller.
Sure. Yeah, thank you so much. I thought this is just very productive and a lot of great discussion brought up. And I'm hoping that you could help with I don't know if your intention was to provide a report or not, or minutes or something of that nature, but kind of what our
goal.
next steps are,
Yeah.
right?
And we'll share it with you and see if we're missing something or if you want to add, delete, make comments.
Yeah, wonderful. But I guess the last discussion we had, in terms of the base year transfer and also the ability of children to move into a home, I'd love to see more clarity. I like the presentation that was presented by Sacramento County, by Jarrett and Linda, about taking a look at how the current law may provide an answer in terms of allowing enough time for these transfers to occur. There was, I guess, another suggestion from San Diego about making it a 3-year time frame. And it sounds like Assemblymember Gibson has an idea too. So if we can figure out how to tackle that, it would provide a lot of relief for folks. I think the technology issue, I'm glad that you brought that up. I'd like to see, how can we provide electronic signatures to counties on a low-cost basis? And it seems like there were some ideas presented today in terms of how to do that. And as far as the assessment appeal boards are concerned, that's just a challenge, because I can see what LA is doing and they're making great progress. But I contrast that to Butte County and just the challenges with staffing. So I don't quite know how to pull that all together. But there were a lot of good ideas here presented, and we'll have to kind of figure it out. I'll think on this some more, and if I come up with something I can glean. But there was a lot of information provided that I think it helped solve those challenges. So thank you.
Vice Chair Lieber.
Thank you. Well, I wanted to give my thanks to you, Mr. Vasquez, and to your staff, and to board ops staff for putting this together. This is a very comprehensive day and quite valuable. I don't know when since university days I've taken this many notes, but I literally wrote every single thing down, and I do plan to watch the video again. And so as I'm sifting through this, I guess we're each going to have our own recommendations or our top picks out of things. And so I wonder if the time on June 18th might be a time for us to be able to submit what we think the most pressing issues are. And maybe there's a date in advance of June 18th where we could get those to staff so that we have the opportunity to get more information and reactions from staff. And I guess I'm calling on our executive director to ask her about the timing of that and how we could best accomplish that, because I think we're each going to have something that's our top 3, our top 5, whatever the number is. And so I'm going to continue to delve into these topics, but I'd like to also get a check from staff on, when some of the tax rules were last updated, et cetera, et cetera.
Yvette Stowers, Executive Director. We're clearly not going to try to do this at the May meeting because we have a full calendar. So it sounds like you guys are thinking about at least your minutes and your report at the June 18th meeting. I'm not sure, Vice Chair Lieber, are you saying that at that same meeting, members will be able to present their top 5?
Well, I'm thinking, I know that we don't do minutes for a work group. And so we're going to have some kind of a report coming out of this that has everybody's input. But then as far as getting to the stage of recommendations, I think we each will be taking our own cut at what we think the recommended steps should be. So would that be able to be done in June?
For you guys to present your recommendations? I'm sorry. Are you asking for something from the agency as well?
Maybe input on those?
That might be a bit of a challenge. I'll give you a second.
Sorry.
I think that it would probably be better if we can see what you guys are looking at first. Because it was a full day.
I kind of figured that. I was kind of envisioning, you know, giving ourselves, I was giving myself, my staff, the 18th to bring it back to you folks. And then if my colleagues are prepared to share at the same time, if not, they could take it and digest it and look at it and see if it's addressing your concerns or issues that you thought were the most important. And if we missed something or you needed to change some or add some, maybe include it. And then in a later date, I guess we would check with you and see when it might be appropriate to have maybe a follow-up discussion or an item on the agenda. And it may not be June. June might be just when we share what we have, and then we maybe take it up the following month or when you think it might be appropriate or time-wise in terms of the agenda.
Okay, that sounds reasonable.
Yeah, I think that's what I'm aiming at, is if we can have a compressed process on June 18th, and then be able to come back, but not wait as long as September
I agree with you.
to
I
come
just didn't
back,
know
so that we can,
staff issues, yeah.
yeah, be able to get that information back from staff after June 18th, because I know that June is also a really busy month around the BOE.
Sounds like Chair Gaines might have a recommendation as well.
Well, just one thing that I think we could do some background on, maybe in anticipation of June, would be this current law may provide the answer that was
The one from
presented by.
Sacramento County?
Yes.
Okay. Well, let me be careful because we're in a board work group and not in a board meeting, so I don't want
Okay.
legal to tell me I'm overreaching. But we've been aware of that problem already.
Okay.
And we are currently working on it.
Okay, so my hope was that we could just get more information on it so that when we do when we address this again, we have kind of all the facts.
Okay, I would try, I'll give
From
you,
the
we
BOE's
can give you at least
perspective.
the basic law. I'm not sure we're gonna be in a position to provide you where the direction that legal was going towards. Because like I said, it's very complex.
Yes.
So they may not have an answer on June 18th.
Okay, that's all right. I'm just trying to
Yeah,
express.
yeah,
it
and we
in the
are working, like I
workshop.
said, we are
Yeah.
definitely working on that one.
Yeah, good, thank you.
And I think Vice Chair Stowe had some more comments. Go ahead.
Yes. And I was wondering, did we get a copy of Mr. Gomez's presentation from San Diego County? I don't think I got that, and not that I ever want to look at that math problem again, but I do want to look at the rest of the diagrams again.
Actually, I think it's in your,
Okay.
or at least I know
Mr.
part of it was.
Vasquez, we do not have Mr. Gomez's, but we'll get it, and we'll be sure it's distributed. That would be great. Thank you so much.
You're referring to this?
That is the math problem, yeah. Yeah, thank you.
Deputy Controller,
Thank you, Mr. Vasquez. On behalf of Controller Cohen, I just want to thank you for the heavy lift today, you and your whole team. This goes to the core of what the Board of Equalization is about, fair and efficient property tax administration. And I believe the hard work starts today. We've heard from stakeholders, we've heard from the public, we've heard from different assessors from all over California. So it's on us now to kind of carry this torch and get this work done. I like the idea of progress reports, whether that be meeting back in June for the full report, maybe checking in one more time over summer, and then when we have our annual meeting with the assessors in September, carrying on the work group if needed, and also seeing how we can implement each recommendation we have. We have a full checklist, so making sure that we're kind of checking those boxes and not taking it all on at once, but making progress, and then also working closely with the executive director. I know there's capacity issues, there's staffing issues, but this really gets to the core of what the board is. And then also for all the speakers today, and we talked about the San Diego County. I believe LA County also reported out today. I didn't see that presentation, so please just get everything on the record. If you can email it or just submit it so it is reflected in the record. So as the Board of Equalization moves forward, we can process this information and come to best solutions. But I thought it was a great day, great two-day meeting, and it's a great way to start Q2 of this year. Thank you.
thank you, and thank you all. And just a little shout out to same member Mike Gibson. I ran across him last night at a reception, and I was sharing with him what we were talking about, and he says, well, I'll see if I could pop in, and to my surprise, he was able to squeeze us in. And at the end of the day, he did mention last night, and again, he reinforced it, that he's ready and willing to roll up his sleeves and see what he can do to, because at the end of the day, I think we're gonna we need some kind of legislation to really correct some of these issues that we're hearing. Appreciate your time. I know we went maybe a little long, and I know we didn't take an afternoon break, so my apologies to the staff there that maybe needed to take a break before the end. But with that, I guess that concludes our hearing, and we're all set for our next meeting coming up. And do we need to announce the date of our next meeting in May?
The next Board of Equalization Board meeting is May 28th.
May 28th, for all those that are listening. Thank you. Safe travels.